When you look at the map of the United States of America, there are hundreds of small states that are invisible, unheard of, but exist and are officially recognized. No, I'm not talking about the states. There are only 50 of those anyway. The places I'm talking about also have their own laws, their own courts, and even, unlike the states, their own citizenship systems. These are lands right in the heart of the United States, but far outside the American system. Native American reservations. In this video, we will take you to the unknown side of America, and maybe even to the truths that are not meant to be known. We will take a closer look together at these inner states that are kept out of sight but legally exist, that have been left behind but have never given up. As the name suggests, the United States of America is a structure formed by the union of 50 states each, with the status of a state and a federal district. The states are entities that, within the framework of the federal Constitution, have their own legislatures, make their own laws, and have their own courts. They can make decisions on their own, such as controlling law enforcement for public order and determining tax policies. But matters such as foreign policy, defense, and printing money fall under the authority of the central, that is, the federal government. However, apart from all these, today the Native Americans, who are the original owners of American lands and are generally known as Indians, also have their own special territories. These are the Indian reservations I just mentioned. An Indian reservation refers to lands under the sovereignty of a Native American tribe that are officially recognized by the United States federal government. In American legal language, these areas are referred to as Indian country or dependent but domestic nations. These concepts emphasize that reservations have the right to self-govern independently within the United States. The word reservation comes from the word to reserve as we know it, and it means an area set aside specifically. This has also been true historically. When the United States Constitution was being drafted, each tribe was seen as a separate sovereignty. Therefore, the lands where they lived or hunted were considered reserved for that tribe. However, over time, this reservation status lost its meaning as indigenous peoples were forcibly displaced and relocated to more distant, less fertile areas. Today, many reservation areas are not the historical lands of those people, but places where they were forcibly relocated. Today, there are 326 Native American reservations within the United States. However, not every tribe has a reservation, because there are 573 federally recognized Native American tribes. While some tribes have more than one reservation area, some smaller tribes have to share a reservation area together. All reservation lands combined cover an area roughly equal to Romania. However, only 1/5 of the entire Native American population in the United States lives in these areas. So what exact freedoms and restrictions do Native American reservations have under the law? According to the law of the central government, that is federal law, these areas are defined as domestic dependent nations. The official definition made in 1830 by John Marshall, who was one of the founding fathers of America and played an important role in drafting the Constitution as the Chief Justice of the Supreme Court at the time, is still valid for reservations today. The definition states the following: each tribe is a separate nation, and their rights to self-governance are protected by law. According to this law, negotiations between the federal government and tribal administrations are also considered intergovernmental relations. At first, when you hear this information, you might think that the founders of the United States were being generous to these people, but when you look a little deeper, you can see the painful history behind it. The United States was founded after the War of Independence from 1775 to 1783. Right after its founding, this new country made rapid expansion in North America its primary goal and began moving westward. In front of them were the native Indian tribes. They pursued a policy of pushing the Indians westward to seize their lands. In this process, sometimes through violence, sometimes through threats, sometimes through deception, and as a result of all these, usually through imposed treaties, the natives' lands were transferred to the whites. With the law enacted in 1830, which officially established Indian reservations, the Indian Removal Act was also passed, allowing for the legal displacement of these people. The law forced Native American tribes to move voluntarily west of the Mississippi River. Yes, they were forced to do this voluntarily, but many tribes, especially the Cherokee, Creek, Choctaw, Chickasaw, and Seminole, did not accept this offer. Some tried to negotiate to stay on the rest of their land by giving up a portion of it. The Seminole tribe resisted displacement during the Second and Third. The Seminole showed armed resistance during the Seminole Wars. The Cherokee people fought within the United States legal system and won the case in the Supreme Court. The federal government and the Army did not comply with this decision. After the law, about 60,000 Native Americans were sent to reservation lands that were given or imposed on them. This mass migration is called the Trail of Tears in American history. The natives who settled on Native American reservations did not have American citizenship at first. They were seen as foreigners for not paying taxes. However, it turned out that these people were needed as soldiers during the World War I. Some of them served in the Army during the war. About 5 years after the war, the Indian Citizenship Act was enacted. Under this law, Native Americans were considered citizens. They gained rights such as voting, Social Security, education, and a United States passport. Despite the law, although a few states granted citizenship to natives living on reservations, they did not grant them the right to vote due to tax exemptions until the Civil Rights Act of 1957. Today, especially those who want to avoid certain legal obligations, primarily tax exemptions, may claim that their ancestors are of Native American descent and seek to become reservation citizens. To prevent everyone from becoming reservation citizens, a practice called blood quantum, which determines the degree of blood relation, is implemented. The blood quantum of a person claiming to have Native American ancestors is determined by looking at their family tree. For example, if one of a person's parents is 100% Native American, that person is considered 50% Native American. If one of a person's parents is Native American, that person is considered 25% Native American. As the family tree grows, a person's likelihood of being considered Native American decreases. Each tribe also applies its own rule for citizenship. For example, the Cherokees require documented proof of ancestry. The Navajo tribe also allows a minimum 25% ratio. In some tribes, this ratio can be as low as 6%. Most reservations, just like states, have their own constitutional systems. They have governing councils, and these councils have full authority in areas such as land management, law enforcement, courts, taxation, and citizenship. However, since they depend on the federal government, they cannot declare war. They cannot make deals with foreign countries or print money. They have to comply with the Constitution of the United States and the decisions made by federal courts. However, this system does not always work perfectly because there are also many ambiguous situations regarding legal procedures and jurisdiction between reservations and states. For example, crimes committed by tribal members are tried in tribal courts, but if one of the people who committed the crime is not Native American, there is no clear decision on how to proceed. When Native American police officers stop a white person for speeding on reservation land, or for example, find drugs in a white person's car, they usually call the state police to avoid causing a crisis. But in such cases, sometimes the state police also refuse to intervene, saying this is not within our jurisdiction. In the middle of the United States, because of legal loopholes and law enforcement officers who refuse to take initiative, there are situations where no one knows what to do with the criminal. These days, most people first think of casinos when Native American reservations are mentioned. The reason for this is that in 1979, the Seminole tribe in Florida allowed casinos which had previously been banned. After that date, other reservations also began to allow the casino industry. According to official data from 2022, there are 519 casino businesses owned by 244 tribes in 29 states in the United States. According to 2022 official data, Native American casinos earned $40.9 billion in total revenue. Before the spread of the gambling industry, Native American reservations were economically abandoned regions left to their fate. The lands given to them are not fertile for agriculture and livestock. They are also located far from economically active markets. All of this made poverty permanent. Despite many moral problems, unfortunately, the casino industry became an economic salvation for Native Americans. As a result, they began offering public services to citizens, and education, health, and infrastructure improved. Some tribes started to pay their citizens a direct salary from this income. They gave students non-repayable scholarships. In recent years, they have been trying to use casino revenues to diversify their economies. The sectors they invested in the most were primarily tourism, including conferences in golf, agriculture and livestock, software, and industry. For example, the Hard Rock Cafe, which has many branches in our country and around the world, was purchased by the Seminole tribe in 2007. The Cherokee tribe, by law, directs 75% of its casino revenues to a business startup fund. Although Native American reservations have shown some economic movement in recent years, due to deliberate decisions by the United States federal government, a significant number of Native Americans living on reservation lands today have lost their health. Here's the thing. Most of America's nuclear test sites, uranium mines, and chemical waste areas are located in regions neighboring reservation lands. Some Native American people were forced to work in uranium mines without protection and precautions. As a result, many died from cancer. In fact, according to data discovered later, it turned out that even the stones of some houses on reservation lands contained radioactive waste residues. The Church Rock uranium mill disaster in 1979, which caused the largest release of radioactive material in United States history, contaminated the reservation lands of the Navajo tribe. Additionally, the river waters were polluted and agricultural and livestock activities completely collapsed. Access to clean water remains a major problem in these areas. Nowadays, many modern Native Americans living both on reservations and throughout the United States do not really resemble the stereotypical Native American characters depicted in Hollywood movies. Most of them are educated, urban individuals who live in modern clothing. Due to marriages with other communities, their physical appearance has also become more diverse. On reservation lands, you can find people who are proven to have Native American ancestors, but you can also encounter Black, Asian, or blonde individuals. Native American reservations are the unknown face of the United States. These are lands not marked on maps, with a history full of pain, where people today are trying to recover through an economy that is morally controversial.